Hi, Matt Gilby, Managing Director of My Agent Real Estate. I'm here today with Amy McIntosh and Leah Stewart, two of our senior property managers, and we're just doing a follow-up piece with the Residential Tenancies Act new reforms coming in to place at the end of this month. We've got a lot of questions coming through from landlords, and we thought we'd go through a few of those FAQs today. So the first one is, who made the Tenancy Act changes?
Rightio. So it was a state government initiative for fairer, safer housing review, 4,800 public comments and 700 written submissions. The input came from the Victorian community made up of renters, rental providers, industry groups and advocates. The key takeaway is for more transparency through the rental market.
Yeah, absolutely. This has been a long time coming. It's been put together over the last 2 to 3 years, and a lot of the other states around Australia have already implemented a lot of these things. So it's nothing to be scared of, is the message that we're going to all of our landlords with. We're right across it. We've been through all the information, and we think it's actually a good thing for the industry. The second question that's coming through a lot is, what is a disclosure statement?
Yeah, so a disclosure statement is a document that the rental provider must provide with any new tenancy and any lease renewal. So the information that is in the disclosure statement will cover things like the minimum standards of a rental property and the compliance checks, just confirming that all of those items have been done.
Yeah, that's right. There's a certain amount of information that needs to be disclosed for any new tenancy and tenancy renewal. Again, it's about transparency. So the landlord is obligated to provide this information for each one going in. The third common one that we've got is, do I have to sign the disclosure statement?
You must sign a disclosure statement for all new tenancies and all new lease renewals. We are unable to lease your property or sign a lease renewal up without this statement signed.
Absolutely. And the other question is can we as agents sign on behalf of an owner? And the answer is no. It needs to be the rental provider that signs.
It is a legal document, so it must be signed by the rental provider.
And this is from the 29th of March moving forward. So all new tenancies and lease renewals, 29th of March moving forward.
Absolutely. Minimum standards is something that Leah had just referred to. So what are the minimum standards? So some of the minimum standards coming into place are functioning locks and deadlocks for external doors, vermin proof, energy efficiency appliances and also showerheads, structurally sound, it needs to be weatherproof, mold and damp, electrical safety, window coverings. Windows need to be functioning as well, kept open in its open position, closed in its closed position. Must have functioning latches, there's lighting, ventilation, and new requirements for heating as well. I won't go through all the ins and outs of exactly how it works, because we do have a link that we can send through for those that want more information. It is in the original link that we sent in the email to everybody as well. Another frequently asked question that's coming through is, what are the new property compliance inspections and when do they need to be done?
Okay, so the new compliance inspections are a gas safety check, electrical safety check, and smoke alarm safety check. So a few of these things we've already had done, but the points of check have changed and the compliance has changed around that. So they're quite comprehensive. We won't go through that all, and we're still waiting for a lot of that information to come across. But what triggers that is a new tenancy. So if your tenant vacates and from the 29th of March you're wanting to advertise for a new tenant, must have a compliance safety check done, and a lease renewal. So any new lease renewal you're doing from March will need the compliance checks done as well.
The certificates, that's right. And they're going to be done by qualified tradespeople, and we are talking with a number of groups to figure out the best way forward with that one. The next one is, why are you calling me a rental provider?
So terminology has changed as part of the reforms, and a landlord is now called a rental provider. A tenant is now called a renter. So you will start to hear these common terms. Bear with us while we probably still call you tenant and landlord for a minute.
Yeah.
This will update on your lease as well. So all terminology on all official documents will be changing to that as well.
Yeah.
Absolutely. The next one is the non-compliance register.
Yes, so basically if you get into a situation where you do end up with VCAT with your tenant, and VCAT rules that you are non-compliant in some way or form, it could relate to any matter of things, you can be placed on a non-compliance register where any future renters can look you up on this register and see that there was a VCAT order against you and also the agent that you had with you at that time.
It doesn't also have to be a financial order. It could be just a determination that you're at fault.
But it does, I guess the key thing here, it has to go through VCAT. So any renter or any person can't just list you on this register. It does have to have, you do have to have a VCAT order against you to be, put on that register.
Yeah. That's right. And look, again, it's rare. The amount of times that we go to VCAT is quite low, and also the amount of times that a determination like that comes out is next to zero. So it's there. It's something that we need to be aware of. However, something that we're not really overly concerned about. Next one is, what happens if I don't comply?
So with the new regulations, if you don't comply with your electrical safety checks, your gas, your smoke detectors, there is penalty units in which the owner or the rental provider can be fined. They are substantial, and each penalty unit is $165.22 up until the 30th of June this year, 2021, and they do increase every year. With some non-compliance, it does range up to the tens of thousands of dollars. So in your disclosure statement, if you disclose that there have been checks where there haven't been, you as a rental provider can be fined and will be fined. Consumer Affairs have advised us that they will be coming down hard on this.
And significant fines as well. They're not going to be minor fines, they will be quite significant.
Yeah. Exactly right. They're very serious about it. The next one is, how much bond can I ask to be held from my tenant?
Yeah, so with any tenancy, any new tenancy moving forward from the 29th of March, rent per week up until $900 per week. The standard bond is 1 month's rent. Any property that gets $900 per week or more is negotiable. So generally speaking, it would be maybe 6 weeks rent that you might ask for on a property that is receiving $900 per week. Anything below that though is only 1 month's rent that we can ask for.
That's right, that includes furnished properties as well. So it's a bit of a change, but again, it's transparent, so we know exactly what the new rules are.
Also, just want to add as well that you cannot ask for an additional bond for a pet, so a pet bond, you can't ask for that moving forward.
Well, thanks very much for watching today. We hope that these frequently asked questions help put a bit more light into the new changes that are coming. We are encouraging everybody, if they've got any questions, just to reach out. We're across all of this information and we're more than happy to give more intel. If there are further questions, email them through. We're more than happy to do a few more of these sessions if everybody feels they would like some more info.